coming this morning. We were told that the compiler had updated the web search for all the laws of Guam and the statutes, and the Chief Justice very graciously asked the compiler to come to the legislature and make this presentation to the members of the legislature in person, and also have an opportunity for the listening and watching public, the viewing audience, to learn how to be able to use that website, because it is an excellent website. And I remember when I was legal counsel for the legislature 30 years ago, the joke was that there were only two people on island who knew what was happening, myself and Jim Brooks, and Justice Merriman.
You forgot
because
Charlie
otherwise,
Troutman.
Yeah, but otherwise nobody else knew what was being passed. And so this really is a great service for the practicing bar, and for everybody out there, that they can at any time find any statute without having to buy the green code books. So, Mr. Chief Justice, I understand you have somewhere to go, so if you would just make an opening statement, then we thank you very much for coming down this morning and gracing us with your presence.
Thank you, and Hafaday, Vice Speaker Cruz, Senator Atta, our Oversight Chair, Senator Aguon. I just briefly wanted to stop by before the presentation from the compiler. We're quite pleased that this presentation is being made here at the Guam Legislature, because it does, as you say, provide an opportunity, utilizing the forum and the ability that you have to telecast these proceedings out to the public, to also act as a continuing legal education, if you will, opportunity to explain the Guam Code Annotated website through the compiler of laws. I know that there was a bit of delay in getting the codes updated to the point that we wanted. We're up to now through Public Law 32-68. And part of the reason why was this is perhaps the most comprehensive and exhaustive review and revision to the Guam Code Annotated that's occurred in recent memory. We've gone back and looked at adding source notes to the codes. We've updated all of the annotations. So it's truly a rework and a process of updating the entire code. And most of those details will be actually brought forth and explained by the compiler as she goes through her presentation today. And primarily she'll be the one responsible for making the presentations on behalf of the judiciary. But we appreciate the opportunity to be here, and we understand that the compiler is prepared to provide additional classes or additional presentations to other members that had conflicts in their schedule before today. But we're quite excited with the changes that have been come, and we of course expect your feedback as well as you go through this. We appreciate the feedback we get, from the legislature, from the legislature's council, both the majority and minority council, and I think that you'll be pleased, I think, though, with the product that you'll be seeing today. And I thank you for the opportunity to be here.
Thank you very much, Mr. Chief Justice, and I understand you have someplace to go, so thank you very much.
I'll stick around for a couple minutes and then go.
Okay. If you would just introduce yourself, Ms. Cepeda.
Yes, sure. Okay, it's right. Yes, good morning. My name is Jerry Cepeda. I'm the compiler of laws. Mr. Vice Speaker, it's nice to be here. Senator Atta, Chairman Aguon. I'd like to also really quickly introduce the staff at the compiler's office. We have Dean Manglonia, the Chief Assistant Compiler, Gloria Duenas-Cruz, and Lisa Ibanez, Assistant to the compiler's office. Thank you again for inviting us to attend today. I just wanted to let you know that initially this had been scheduled for the Guam Law Library, not to force anybody to leave, but primarily to let people know that the compiler's office is at the Guam Law Library, and we have a wealth of resources, especially those related to Guam law. We have as far back as the 1953 codes, the 1970 codes, and anything that might be related to the Guam legislature. So that's something that I wanted to extend just to let everybody see exactly where the compiler's office is. And we'll be having presentations Tuesday to Thursday. So tomorrow, Wednesday, and Thursday. And that'll be at 10 o'clock in the conference room. Anybody that wasn't able to attend today, I really would be glad to see them there. Let me see. Just to start here, next slide. The purpose of this briefing is threefold. Primarily, although I understand most people know how the compiler's office works, but just to go into a little more detail. Also for the viewing public, this would help them understand the role of the compiler's office and the critical role it plays in ensuring that Guam law is available to the public. Also, to explain the process of updating the GCA, exactly the nuts and bolts of what goes on in our office. And finally, and probably the most important, is to highlight notable changes that have been going on in the code that we've instituted with this most recent update. Our statutory mandate is to publish Guam law, period. That includes the GCA, the Guam Administrative Rules and Regulations, as well as other government publications. And specifically relative to revision, codified in 1606, these are exactly what we are allowed to do. So, I'll touch on it here, but later on in the presentation, you'll see the relevance as it goes on, how it works in our office. Number and renumber, rearrange, change reference sections if certain things have changed, substitute references to chapters, strike out repetitive figures, capitalization, and critical is the last one, to correct manifest clerical or typographical errors. To the extent that we can, this is one issue that we always have, we'd like to focus on. If it's just not clear, we do need to just clarify that. Okay. Oh, and if there are any questions, please feel free. Everyone here is familiar with the process. Bills are passed by the legislature and they're enacted into law either by signature, by lapse, or pursuant to an override. At that time from the executive branch, we receive the signed PDF version. It's incredibly difficult to work with, although we do have some technology. So generally we wait for the Word version from the legislature to be transmitted. And it's at that point that the analysis begins. Whether to add it to the code, this might seem obvious, sometimes not so much so. Where to place it in the code, again, it might seem obvious, but not so much so. And for us today, a focus will be the annotations. So these are the three things to keep in mind as I proceed through my presentation. We update the table of code sections affected, which is incredibly helpful if you want to find out what it used to say and where it went to, what happened to it, whether it was repealed, whether it was moved. This is the table that you'd look at. And we have that updated for all the legislatures from the 28th since the publication of the Green Code. And the final step is to update and upload. And that's to the website, since publication is now permitted online and not just in print. Annotations include are categorized in 5 ways. The source notes, and this is something where, as a legislator, as a researcher, and most especially as an attorney, you want to know, where did this come from? Is this a creation of the Guam legislature, the current Guam legislature? Is this something that has existed since 1950 with the enactment of the Organic Act? And this is where the source notes would play a role in assisting research and finding out exactly what was the rationale a certain law was passed. Generally found after each section. Next are explanatory notes, and these are usually preceded by a year, especially since online publication, just to let you know when that was added. And this would be detailed information about where things went. Say a law was repealed, but it was moved somewhere else. That would be in an explanatory note. For the most part, comments are subjective comments from the compiler. Generally, since I've been the compiler for the last 2.5 years, I've generally shied away from that, only because my perspective, the legislators would speak for themselves. The prior compiler had another perspective, so we are reviewing those for relevance and for accuracy. But you'll see, for the most part, any comments would not have been added by myself. Court cases are something I'm working on, and this is aggressively, I'd like to have citations to current Supreme Court opinions. I mean, that's a body of law that is not represented in the code. And the GCA, the A means annotations. I think having court cases would be an important part and a really useful feature for the public. Finally, are cross-references to other code provisions. Those are something we are also working on, and that the prior compilers have not spent too much time on, but where relevant or where it's really useful, you'll see them. This is just an example, a comparison of the annotations with and without. If you see, the former codification had no source notes at all. I mean, probably at the very beginning of this chapter, there would have been what added it. That's what I'm thinking. If we went back to the old blue binders, which many here are familiar with, it might be there. It might not. But I thought it was important for everyone to see what exactly, how this statute came about. It was added, so it's been there since 1977 as the government code. Just to see all the changes that have progressed through the years. And then when you see the 2013 note, it actually was another section. It was called hospital rates. And that was repealed in 2010. But just to see the difference, I mean, it doesn't happen overnight. We're talking research through the public laws and through the Guam code, or the government code, from nothing formerly to all this information now that would assist anybody that's researching this particular issue. And the Board of Trustees for the Guam Memorial Health Authority, or Hospital Authority, I think is on the horizon for quite a few people. Another example is the duties of the Board of Trustees. Again, this is Title 10, Chapter 80. This is the Guam, the GMH. And again here, you would have section, it ends right here at Section F, because there were no source notes. That was added with this recent compilation of the recent codification. And it shows here the 2013 note. If you wanted to find out the source for the hospital charging fees, it used to be 80105.1. But now it's in 80109. So if you wanted to look for it, you would find out where it is. It's not a matter of, gee, I wonder where it went. It used to be here. And where did it go? Otherwise, you would never know if we hadn't put in the source note. This is one that probably would interest the speaker. Good morning, speaker. This is the age of children being required to attend school. That you figure it must have been passed in 1998 or 1999, maybe previously, because that was the effective date. But again, without a source note, you would not have any way of researching this information. Easily, I'll say easily. You could find it, but it wouldn't be as easy as opening up your computer, typing in the section, and seeing, oh, okay, the most recent update was in 1999, and it was originally found in the government code. This is information that we believe in the compiler's office is part of our duty and is also important in terms of informing the public about the source of the law. I mentioned earlier the 3 parts of our analysis would be where to put it, whether to add it to the code, and then secondly is where to put it in the code. In many cases, when laws are passed and numbers are suggested by the Guam legislature, Part of 1606 does allow the compiler's office to codify and place it in somewhere that makes maybe a little more sense or might make it easier to find. One example is Public Law 3215 that suggested retention of electronic email correspondence would go under Guam procurement regulations. I mean, it's open. There's nothing keeping it from being there. It's available. It's not taken up by another spot. But looking at the code as a whole, and that's something our office does, is it makes more sense to put it here with retention of procurement records and record of procurement actions taken. So if you wanted to find out where do I find a record, it would make more sense to look here rather than under procurement regulations. So this is the analysis that we do to make sure that laws that are passed are easily discoverable. Another reason for recodifying is here. Section 8050 was added regarding habitual offenders. Although there is no Section 8050 in Article 2, there is one in Article 3. So codifying it there would create a problem in terms of 8050 either implicitly repealing the existing one or just being difficult to use. Nobody would know. It doesn't make any sense. You'd have to say all the time, 8050 in Article 2 or 8050 in Article 3. So what we did is we moved it here, which was available to 8039 habitual offenders, which makes sense in terms of repeat offenders and multiple offenders. It's easier to find, and also, it just fits better there than under fines and restitution. Habitual offenders address the length of imprisonment and not a fine and restitution. So that's the analysis that we do when we receive a public law. Another example is here, procurement for the Municipal Planning Council. Title 10, GCA Chapter 51 addresses the solid waste management host community. Procurement was passed and codified by in the public laws 5120, which is the procurement code, which makes sense in a way, except it's a lot easier to find if you're talking specifically about procurement for solid waste authority and the Municipal Planning Council host community issue. It makes more sense to put it in Title 10. So when I say we look at the code, I mean the code as a whole, as an entire body of law.
I'm
Yes.
sorry to interrupt right now, but I'm going to forget. You're doing this recodification, and the laws that were passed, signed into law, of course, listed a separate section.
Yes.
And however, because of your analysis, you felt that it would be better elsewhere.
It would be a better fit.
So,
yes.
and that makes it difficult, of course, for us, and that's why we had asked for this meeting, not knowing where it was placed, and that. Have you sent any letters to the legislature asking that maybe we need to go back in there and then change, the sections where it'd be most appropriate, where you think that it would be, so that then everything would be aligned?
As part of the codification process, the table of sections affected, it would show that public law, for example, Public Law 3221, Section 4, had enacted 5120 and that it had been renumbered and recodified to this section. So there is a way at this point. It's part of the general process from enactment at the passage at the legislature, enactment at the governor's office, and then codification with the compiler's office.
But it's not changed at all.
No, it's not changed at all.
Morning, Madam Speaker.
Good morning.
You weren't here when I was originally giving my presentation, but I think for the edification of the Speaker, I think it would be important to show the authority that the legislature has vested on the compilers in terms of going back, and so that she can understand that section at the onset, and then I think that will provide some elucidation for her with regards to the ability of the compiler to proceed in the manner that the legislature has authorized.
Yes. So this was just to go back. Thank you, Your Honor. This
I'm
is
sorry,
To go
no,
back to,
I don't want
yes,
to
This is just to
prolong
go
this,
back
but-
to the statute, and this is what allows us. And it really, although it makes sense that we'll stick to what the legislature says, in some cases, as I explained, it makes more sense looking at it as a whole, which is what the compiler's office does. You're focused, and I understand, on a particular piece of legislation in front of you and the issues that arise from it. However, taking a look at the body of law, and although I haven't memorized all 22 titles, and I don't think I'm going to get close, we do live with this law. I live and breathe this law. I can say I'm the only person, or one of the few people in Guam, that reads everything the legislature passes, including punctuation. So this is something that when we look at a piece of legislation or a newly enacted law, we look as a whole, where would it best fit, and where would it be easiest to find. And in this case, it looked like it would be the host community, because that was what the procurement was arising from. Rather than digging through the entire procurement code, Title V is huge. As you all know, this is something that is constantly struggled with by the Guam legislature. So when you want to focus on the specific issue of procurement, that's when we that's when we thought of placing it in Title 10, Chapter 51.
I think maybe just to follow on to the speaker's question, normally when I would do my research for certain, my short-term memory is better by, let's see, I remember it was in public law, whatever, and so in there, we include in the sections
Yes.
that we are then adding a new section to a particular section of the law. But then when you start then renumbering,
Yes.
and so when I go into that section of the law, it's not going to so I'm just not quite sure I follow how when I go to that section that was originally referenced in the bill here,
Yes.
and when I get into GCA,
Yes.
how do you then guide me that it is not in this section but was in fact renumbered?
It would be in the source notes, but also what I'm thinking is you'd probably also use the search engine, and the search engine would find where it is if you were to type in that public law or the name of the statute. But it would also be in the code table of code sections affected, and it would be indicated in the source notes also. Yes, Mr. Chairman.
Ask you to refer to that page on habitual offenders.
Okay. Oops, here we go.
Now, you highlighted that you transitioned from under the Article 2 imprisonment over to Article 2 imprisonment, and you added that 80, subsection 80.39. My question is, because there was a pre-existence of a subsection 80.50.
Yes.
Now, isn't that where the legislature really has to come in and clarify it, or you just go by the intent of the legislation, the law that was passed? Because if the legislature identified in the legislation that was passed into law, subsection and new subsection 80.50 is hereby established, when in actuality there was an oversight and there's already a pre-existing subsection 80.50, so it really is an error on the part of the author of that legislation in terms of making sure that there's this recognition. Because to me, the way I look at it, I mean, what you've done here is you put it in the appropriate provision in the code, but then again, it's a discretion that is given to you when in actuality there was already a pre-existing 80.50. And
Yes.
was it the intent of the legislature to change the existing provision, or did you go in and do a little bit of research and clarify that it was supposed to be a new subsection rather than deleting what is already in the code?
Okay.
You
See,
understand what the
yes, I
confusion
do,
could be?
exactly. And this is part of the statutory mandate in 1606, that subsection that says correcting manifest error. Clearly, when we looked at this, habitual offender is 8050. The first sign is it's a different title, so there was an intent to get rid of the old one. The second sign is that they had added it to Article 2, so they had meant for it to address imprisonment and not fines and restitution in Article 3. So those are obvious signals, but also, when you look at it, it's clearly a different law. They had not intended for it to supplant 8050 fines and restitution in a sentence. They had wanted it to be an extended term for a habitual offender. So that's why when we looked at it as a whole, we saw it fit better under imprisonment, and that would have been clearly, something more along the lines of an extended term, rather than completely, superseding fines and restitution 8050.
So just as a follow-up question, I understand your transition here.
Yes.
And certainly it's in line with the mandate that's given to the comparative laws. Then it goes, my question now goes back to what Senator Ada had just brought up. How would he know that subsection 80.50 dealing with habitual offenders now has been transitioned over to a different part of the Guam Code, annotated, other than the search engine?
Other than the search engine, it would be the table of code sections affected.
So it would not be highlighted under Article 2, right here, right after 80.49?
No, well, it would be, I'm trying to think. Sometimes what we do, and I'm trying to think off the top of my head, that we would put it, but we would say it's been recodified to another section.
Okay.
So we would put it there, but then it wouldn't, the note would say it was enacted there, but that it had been moved.
That's fine with me, because
Yes.
at least there's a little bit, there may be some annotation there that in fact it may have been.
I'm trying to think, I don't know off the top of my head, because this was an ongoing process, but that's a very good, and if we're not doing it now, it's certainly something we will do. I know we've done it for others. I don't know if we've done it for this particular one.
Now, one follow-up question again. To prevent you from doing much of this legwork,
Yes,
I would think that, and I think it's good to recognize that some of the senators have key staff members here, because it's really where it all starts, and that's here. Would it be beneficial if, in fact, I understand you read all the codes, you read all the brand new laws, but would it be beneficial if, in fact, all proposed legislation, at least courtesy copies, be presented to you, so if you're able to identify? Or
would
is
you be
that
surprised to know that I already kind of do keep track of the bills that are introduced?
You do? Okay.
I do. And then there's some issues where, when I have received calls in the past from office staff saying, is this a good place for it? Although it's not my place to recommend legislation, something like codification, I'm always happy to meet and chat with staff, and I've done it in the past.
Okay, thank you.
So this is nothing, if there's an issue, and you'll see later on in the presentation, I have brought it back up to the legislature.
Before we get further,
Sure.
you indicated earlier that one of the responsibilities of the compiler is to do some analysis of the laws that have been enacted, and under that was where in the code to add it, which you've shown here very well, and then also was whether to add it to the code.
Yes.
Can you explain that a little bit?
I'll get to that's one that
Okay.
I'll be addressing in a little bit.
All right. The other question the other point that you addressed earlier was the issue of comments.
Yes.
And you indicated that at least under your tenure, you kind of shy away from trying to second guess what the author of the bill was doing. So to get away from that, for example, I'm working on a procurement bill, and if I was going to put all the comments underneath as to, what were you thinking, I was basically using footnotes, which won't necessarily go on the floor during the debate. So I'm just wondering, how should that best be conveyed to the compiler? And whatever you do with it, that's up to you, but at least there's something in writing as to what the author was thinking of.
In that case, if it came with the legislation, that would not necessarily be from my office. The way I view a comment, just to distinguish, is as a comment that the compiler is making as to a certain piece of legislation or a section or something very subjective. If it was something like what you're talking about, the legislator's comments, that could be an opportunity for the compiler's office to have a new type of comment, to say notes from enactment or notes from the committee or things like that. Because what I'd want to distinguish is a comment from the compiler's office in codification and a separate comment from the legislature saying this is what we're talking about with the law. Do you see? So that would be maybe an opportunity for another type of comment.
All right.
And I'd be happy to meet with your staff if they had any more questions.
Okay.
But on just a follow-up on this question, should there be a question, of course, in interpreting that law, would you still have on file, I don't know how, to be able to look back and see what the intent of the legislation is? Because what we started to do a couple of terms back is actually having a legislative
codified.
intent.
Yes.
And is that part then of it being compiled somewhere?
What I would do in that situation is defer to the public law. Because whether it's in the compiler's note or not, the public law, generally Section 1, indicates legislative intent. So the source notes, as indicated here, would tell you specifically what the public law was. And if there was a question with regard to the amendment in 1999, Public Law 2585, Section 1, clearly would say the legislative intent.
Okay.
So in terms of some big, far-reaching comment, I, as the compiler, generally would shy away from that, because I don't believe it's the role of the compiler to comment on the reasons for enactment. I let the laws of the legislature and their intent speak for themselves. I've noticed, I think it was starting with the 30th and the 31st, legislative intent has been codified. So it makes it easier for us and easier for yourselves also. I'll go back to the recodified provisions. With 31237, although that was the previous legislature, the effects were far-reaching, and I bring it up only because it's the end of the school year. Also, 15A had been renumbered because identical numbering would have led to the same problem with Section 8050. So that was renumbered to Chapter 28. That is indicated in the code also. I'd like to bring up the alphanumeric scheme, and I've been very fortunate. The previous compiler focused on this feature of the Guam Code annotated, to achieve uniformity and to make it easier for citation, as for the most part. If you take a look, it goes alphanumeric, literally, number, letter, or letter, number, letter, number, letter, number. It makes it a lot easier when you're trying to search for something. And this might be another reason for recodification. If the prior code, and I'll go to the next page, doesn't comply with it, as you can see here with the red, the strike through, we went ahead and just changed it. And also we changed the formatting. It makes it easier to read, easier just to absorb in general. And it doesn't hurt in any way what the laws are, but this is just part of the codification process and making it easier. There won't be a question. Every time you get something from the GCA, it'll be number, letter, number, letter, number, letter, in accordance with the codification scheme. And that scheme's been made available on the website for anybody that has questions. I've fielded quite a few calls from executive branch agencies as they prepare their GAR provisions, and I provide them with this. And here's another example. And we call these alterations only because we're altering the numbers and not necessarily changing any of the words. So here, from lowercase a, and it doesn't seem like a lot, but for us in the compiler's office, simple things like capitalization, they do matter.
So would you recommend that we take that particular sheet and perhaps, Madam Speaker, incorporate it as part of our training process?
That would be excellent.
Yeah, so that you don't have to fix it at the tail end in terms of codifying.
That would be excellent. And I have received calls and I've chatted with staff members of several of the senator staffs. And I've brought that up. It is available on the website.
Just so that we can also assist the
That
process.
would be wonderful.
Yeah, thank you.
And another far-reaching, let me see, mental health has been renamed to Guam Behavioral Health and Wellness. So it was a matter of going through all the code provisions, and anywhere there was a reference, we would have changed it. And of course, added a note pursuant to this public law. That's why it was changed. And Senator Atta, you had mentioned whether to codify. This is just the start of that issue. In Public Law 3243, this was passed. It wasn't codified. The decision was made at the legislative branch for whatever reason, but it was important enough for the compiler's office to say, hey, net pay not permitted. This was part of Title 10, Chapter 80. This again was the hospital authority, and it was about net pay of staff being counted in some type of, I think it was retirement. So this is another issue that we face. If there's something significant enough that we'd like to codify. Ooh, can I go forward? The open government law, this saw a lot of changes. Yes?
I don't quite understand when you say it's not codified.
It was added, it was a public law. So it's like, say, section, if I go back to this one, it was a section of that public law, and the decision was made not to codify it. It was just passed in the public law. But it's important enough, and if you look at the legislation, that it should be part of the code, a permanent part of the code.
I guess where I'm a little confused is the use of the term uncodified.
Yes, it was not passed as part of the code. If I can show here, I'm going to jump ahead because I think this will help clarify. With the Budget Act in 2014, that Annual Appropriations Act, these were all part of the Budget Act. These were not codified. If you look through here, this was codified as 1103D. This was added at the compiler's office stage. When it was part of the Annual Appropriations Act, you can see the reference to 1103C regarding home use of government of Guam vehicles. This has been a part of the budget code for at least the last 5 years, that when I went back, of the Budget Act. This has been passed as part of the Budget Act for, I'm trying to think off the top of my head, maybe 3 times, at least 4. So it's just part of the Budget Act.
Yes, but normally because it is an annual appropriation, then the intent is that it's for that year.
Exactly.
But because sometimes, based on the economy, then it, was decided that we want to go ahead and have it again take effect the second year. And I know in this case you're saying it's been there for 5 years, but to codify it, then in essence it would. So let's say in the 6th year, we decide that we no longer need to do that, but you've codified it already.
We have codified it.
What
yes.
requirement now what needs to happen for us to go back and then repeal that section because you've codified it?
Okay, well, I guess the question would be, when we look at what is being codified with this particular section, it's not an appropriation. This, if you look, is a restriction on the home use of government of Guam vehicles. So it's not in terms of an outlay out of the government. It's a restriction that was placed with direct reference to an existing section. The existing section is 1103C.
But you've made that decision, though, to codify it when that wasn't the intent of the legislature to codify, because it's something that we've considered, and every year, and
Yes.
and there are times, of course, when some sections are no longer reflected on that annual budget. So, the question now
okay.
would be then, since you've codified it, because you've seen it already for 5 years in our budget, and suppose, let's say this year we decide that in the next fiscal year budget, we decided that we're now going to go ahead and leave it up to every department and agency to decide the urgency of, taking those vehicles, home for whatever the reasons are. That we're not going to put it anymore. We're not going to make that a restriction. However, because it's codified, it is still a restriction. So does that mean now that we have to go back and repeal that section for GCA, section 1103D?
You would do it the same way that you would repeal the public law that enacted it.
No, but it's it's on a budget every year.
Yes.
So on that budget year, we need to go put that exact same section
Yes.
and repeal it.
Yes, you would. And I understand your concern, and that you're saying that this is something that wouldn't have been, that is extra work for the legislature, is what I'm hearing. That you have to go back and now repeal
Well,
that.
it's not so much the extra work. It's sometimes just not, remembering that we need to go back, that we don't have this kind of a tickler file to go back and say we need to do this. There are certain sections I know that we've done, we repeat every year.
Yes.
Where we allow, let's say, certain limited term employees only because of the situation we're in. Take, for example, teachers, to allow them to come back to be hired on a contract basis. And it was because the situation was so bad, we were always hiring off island, and we needed certified teachers. So we allow now retired teachers to come on. Now we're hoping that the time would come, based on other legislations where now we provide scholarships for individuals who want to become teachers, that at some point, we're not going to need to maybe hire back on contract retirees, because now we're going to have an influx of teachers, and we don't want to do that anymore. So, and then that has been going on for years now. I would say, 14 years. So was that particular section codified then too?
Well, I go back and look.
Yeah,
I don't know off the top of
you're
my
right,
head.
because that one's much longer than this.
And you'll see there's actually 2 more slides of the sections that were codified. But the goal of the compiler's office is to make sure the law goes out to the public. And if it's something that has been considered important enough by the legislature to include in the last 8 budget acts,
Okay.
would have been something for the public to make it easier to find. Also, it still exists in the public law, whether or not it's codified. It still exists as a separate section of the public law, of the Appropriations Act. Codification doesn't necessarily supersede. It makes it easier to find because it's now in the code, rather than searching through all 32 separate legislatures to find that particular section. And here again, yes.
Just on that note, Ms. Cepeda, my understanding, and obviously I need some legal guidance in regards to this, is that anything that's uncodified in the code, in the budget law, reflects that fiscal year mandate. Now, what you're saying is that you've gone in and taken some mandates that have been repetitive in nature for 5 years or more, and now have codified it, which to me is fine, because obviously we just need to do a little bit of additional legwork to make sure that if that's not the intent of the legislature moving forward to the next FY, then we can make the appropriate adjustment. But it goes back again to that premise that the fiscal year statutes that are not codified per se would be reflective and applicable only during the course of that fiscal year. Now, you're saying that those provisions, even if they're not codified, continuously apply, even if the next fiscal year budget is adopted, and there's absolutely no mention of that.
They would exist as a public law separate in the Budget Act, and they would be up here in the code, and the source would be the Appropriations Act. So it wouldn't be a question of, well, what are we going to do with it now? They're important enough by the legislature to be included for, this next section was in the last 8 years when I did my research. So for the last 8 fiscal years, they've been considered important enough by the legislature to pass. But if you wanted to find it, you'd have to go through each one. But if it was codified here, as well as these sections which all go to reports requested by the legislature, for the most part, these are reports, prior year's appropriations report, a transfer report, a tracking report. It makes it easier for the legislature actually to be able to find it, to say, oh, now I know where is this report? Where can I find it? I don't need to look through the last 8. I know it's there, and I can see exactly where to find it should we need to look at it again.
See, your presentation is, I think it's fine because you're looking at the historical aspect of the legislature and the action of the part of the legislature, but then I need to look at the legal timelines and application of some of these provisions. Because if in fact it's not codified intentionally by or unintentionally by the legislature in a fiscal year budget,
Yes.
then the question is that only applicable during that entire fiscal year? You're saying because it's codified now it's applicable indefinitely until
No, I
the
didn't say that. I was saying
No.
the source would have been the Appropriations Act. The codification process is for ease of finding these sections, to want to be able to find it, and now we know, yes, it's in the code. If you look at the source note will say it's an Appropriations Act, and you'll know as an Appropriations Act source, it would only be for that legislature. But if you wanted to find it, whether next year, even if it was repealed, you'd be able to see that it was there.
Okay, thank you for that clarification, recognizing that it's in the Appropriations Act and you
Because
have
these,
some
these are
source
all from
notes.
the Appropriations Act. All of these sections, if you wanted to find it, they'd be there. And some of them really are not that controversial in terms, when you look at it, it's not like this is how much we're going to be spending. It's, are we going to allow senior citizens bingo winnings to be not taxable for 1 year or forever? How would you even find it? If it was in the public law, that one section, I won't comment on that because that's outside 1606. But approval of financial agreements or arrangements. Seeing that it was in the last few budget acts and the fact that it doesn't arise directly out of an appropriation, the call was made to, yes, to codify it. It was important enough for the legislature to require approval. Now we can find it. And now there's no question of whether approval needs to be made. Yes, it does. It's in the code. It's always existing in the public law. Whether it's easy enough to find in the code, now it is. So these are some of the sections that were codified, mainly to make it easier to find. I mean, these have been considered significant enough by the legislature to include. I know specifically this one, I stopped at year 8. I mean, I went back to 2003 for 4GCA 6506, this retirement option. It's been there every year. So if I can go back, I just wanted to talk about the open government law. This is something that would interest, I'm sure, this body, as well as the executive branch and the AG's office especially. They do have to deal with receiving reports. In Article 1, the note was substantially rewritten from Mr. Troutman's days. And another feature that I want to point out is Section 10104. The prior codification had limitation on right of inspection for 2 different sections, 10108 and 10104. For whatever reason, the decision was made not to codify this part. It was in a note, for whatever reason. After an analysis here, this is what it used to look like. There were 2 sections, and there were conflicting sections addressing exactly the same topic. So it was confusing and really not an accurate representation of what the legislature wanted. When we went back and we looked at the public law, you'll see now it says 10104 electronic communications. That's because in the 25th Guam legislature, this was added. And for whatever reason, it wasn't codified. I'm not sure why, but when we went back and we looked at the analysis, clearly there was an intent by the legislature that this would supersede the existing one. And part of that was because 10108 was still there, so the limitation was never removed. There was an intent to rename it to this particular section. And that again was back in the 25th Guam legislature. You'll see here source notes were added after each section, which makes it easier to understand what was going on. And also an Article 2 note was added. Again, this was back in the 19th Guam legislature, when they added the right of inspection. The right of inspection that was indicated in 10201 in Article 2 was repealed. Again, because there was another law on exactly the same topic. And it was clear when you look at the timeline that the legislature hadn't intended to add two sections on exactly the same topic. So the key here again is looking at the source notes and the explanatory notes. It helps understand what happened, what was going on, and to be able to do so quickly and easily, just looking at the compiler's notes rather than slogging through, and I'll say slogging through at least 4 or 5 different legislative public laws to find out exactly what happened. And finally, this is something that we've been asking. This was enacted on the 31st. If you look at here, Section 40 of Public Law 3177 added a new subsection. And we're unable to find out exactly what subsection to add, what section to add it to. There are at least 2 or 3 possibilities. This in fact was the budget law 3177, added subsection I of Article 5, Chapter 1, Title 5. Bond proceeds. We don't know where to put it because we don't know a section number. There are at least 2 or 3 sections it could feasibly fit in and reasonably be interpreted as. And if there's any assistance that I can gain, this is again part of the process. When I say we look at everything, we look at everything. And even after that much analysis, we haven't been able to figure out where to put this.
And when that instance occurs, does the compiler's office come back to the legislature and?
I have.
Okay.
Yeah. So I just wanted to bring it up. This is one example. This I think is probably, for me, it was probably my first couple months at work, so I was like, where do I put this? So we'd like to be able to put it somewhere it really belongs, because I'm sure whoever receives the bond proceeds would need to know this information. And again, this is, when I say we look at everything, we do look at everything. When you want somebody to look at your laws, that would be me. Everything down to the punctuation. And the goal of the compiler's office as a whole really is not to take anything extra, but to make sure what is given to the compiler's office in form of a public law is made available to the public. And that includes not just the constituents, but the attorneys, the researchers, people who are looking at the law. I fielded questions from people off island regarding this, and they have used the website, and it is important because it's our law. It's our law. It's what governs us, and it's important that the people and the public know what's available to them and what applies to them. And going forward, we would like to work on the GAR, and I've been working with the clerk's office to get some records, because this is the next big thing, is updating the GAR, and finding from the 27th on what exactly had been transmitted so we can make that available to the public as well. And of course, obviously working on continuing the GCA updates up to 136, which was the most recent. Any questions? We are in the Guam Law Library. Our website is there, our address. Of course, you can always call us, and I believe most of the senators have my direct email as well as that of the staff. And thank you. There are no other questions. Okay, we have Dean, Gloria Duenas-Cruz, and Lisa Banyas. Dean Bengonia. So I thank you for your attention. If there are any other questions, yes.
Yeah, just one follow-up question. Thank you very much for your presentation and some of the updates that you have incorporated now into the system that you're overseeing. Now, my question is, you're current up to 32-68.
Yes, we're working on 136 now.
Just so that we have a general estimated timeline in terms of when you could possibly be current to 32-136, are we looking at within the next foreseeable 6 months?
I'm hoping summer.
Just so the public
I would
understand.
think, yes. My goal is, the first one I obviously was the hardest.
Yes.
And that's on top of, last year we worked on Title III. I don't know if you've looked at Title III. We've added source notes to all those sections it was the complete rework of the election code. So that did take a chunk of time because we went back and looked even back to the government code. Now we're hoping, now that we've got a little more experience under our belt, mainly me, they've been here, I haven't been here. So I'd like to move faster with this instance because I know how important it is also.
No,
I'm
I
hoping
don't
by
want-
the end of the summer.
I understand that you've been working this very aggressively, you and all of your personnel. So that's not to try to, I'm sorry if it appeared as if in fact I was trying to put your back up against the wall. It's just so that the public would understand. The compiler of laws now is current up to 32-068. And by the conclusion of summer, hopefully, will be current.
I'm hoping. That has been my goal. We are working on it already.
And you do have a disclaimer or a statement.
Of course.
Once someone goes into the Guam Code annotated that in fact all the provisions contained herein are current through Public Law 32-68.
Yes. In fact, if you open up the code provisions, it'll have a little header, or I'm sorry, a footer at the bottom that indicates the last update.
Okay.
So you'll know that there'll be a little COL and then a date. So that's the most recent update and upload.
Okay, then let me just close with this comment, Attorney Cepeda, and to all of your team members. Thank you very much. I really appreciate your efforts. Thank you.
Thank you for having us.
Thank you very much. I'm going to go ahead and allow our staff at our Minority Council and our clerk's office also to ask any questions because it's important that, if they have any concerns, it'd be good. So
Yes.
we have, of course, our Minority Council, Mr. Spaldon.
Maybe if we just,
Yeah. No, you just go ahead and go there. Maybe that might be best. Are you okay with that?
well, actually, real quick.
Grab a chair.
Actually, it's a very simple question, and it hasn't it really doesn't relate to anything that you presented to us today. But in terms of the operation, sometimes I try to download or copy, straight from, and we can't. Or there's several procedures, and I'm just wondering if there's a way to fix that.
You would ask me an MIS question?
Well, again, sometimes when we're in session,
Yes.
and there's a need for, the senator asks me, can you get me that law? And so I'll go, and
To the
of
code.
course, I'll do the search, right? Do the search engine, we get to the code and everything else. I can't print it right on the spot. I'd have to basically highlight it, transfer it over to Word. I'm just wondering if that's part of the process that you're looking at, that people can actually download without having to do
That is.
without having to print the whole chapter,
Have
right?
you-
We just want to get a section sometimes, and it's
So
a
like-
very difficult task.
That's something we'd have to look into.
Whether or not it's the document's OCR. Usually, if we convert from a Word document to
Oh,
PDF.
Can
Oh,
we,
I'm sorry.
yeah, it'll be best because this is
I'm sorry.
recorded and then we can go back and review.
When we convert from Word to PDF, it's already OCR. So I just need to verify that that is happening.
What's OCR? Sorry.
Oh, I'm sorry. Optical recognition
Oh,
text.
okay.
Yeah.
Yeah. And
So
again,
that
without
you
getting
can
too
search
detailed,
and just
and just
highlight
and print.
Yeah.
I have not been able to do that, and that's the issue. Sometimes when we're in here, and and sometimes things arise on the fly, and so one of the senators will come out, give me that law, and so I'll find something, but I can't, within 1 minute time, get the law to the senator. I have to kind of go through this whole process. Sometimes by that time the debate's over, and I've never gotten him anything.
Okay, we'll check into that because it
All
is
right.
critical. Part of the compiler's office, or part of providing the code online, is that it's available to be copied as text
Right.
rather than as image, which I think is what you're saying.
Yes,
So we'll
yes.
check on that.
I appreciate
Because that is
that.
the goal. I mean, for us, there's no use having an image. You don't want a photo of the laws.
Right.
You want
That's
the
right.
words. Yes,
We
so
just
we'll
want
check
the
with
words. I appreciate that.
Do
Thank
you
you.
recall what section?
All sections.
Oh. Was it the most recent update?
I just know that I'm when we're
Okay.
in session.
We'll definitely
right?
check with
and,
that.
And all I need is that one, that one provision. And I don't know. Correct me if I'm wrong, Mr.
Have you
AG.
had any
Right? You
small
had your own.
issues?
Yeah, it's a lot easier if you could just
Yeah.
Okay. One thing
Same
I'll
copy,
say
right?
to check is just to mention both of you. I was going to say it might be the type of Adobe you're working with. If it's Adobe Reader, you may not be able to, and that's the question of the software that you're using being compatible with what we have, because ours is OCR, which means you can copy it as text. But if you're on your end, you don't have that same, you don't have the parity,
Right.
then that might be the issue.
Okay. All right. Thank you. Thank you, Madam Speaker.
But also, I would say if anyone's too shy to speak now, I'd be happy to field any questions later or in email.
I think what's also important you just mentioned is that I think maybe our systems are not in sync, so we can't communicate, and maybe it'll be important to find out what it is that you're using and if it's something that we need to do to upgrade as well. But please find out what needs to be done then and let us know. And I'm sure the AG's office also would really appreciate that, because they too need to have it at their fingertips.
Yes, I would say working with any of the more recent Adobes would work. If it is Reader, it's more difficult. I think that's where you may not be able to. And Reader is the free version, so. We work with Professional, which I understand is not cheap, but it's also the level of features that we need in the compiler's office. So I know if you had Adobe Pro, that would be the level that would work across the board.
On another note, and this is more for the edification, I think, for some of the staffers, maybe who are watching their own office and here, access to Westlaw, right? And again, this is, I think, more of a plug for you guys, just to make sure that everybody understands there is access to Westlaw at the Guam Law Library.
The Guam Law Library is happy to provide free access to Westlaw, or for people who are familiar, LexisNexis, and that's free of charge.
Okay.
And that's to anybody in the public that wants to conduct research. Partly, this is why I wanted to have it at the Law Library. Again, anyone is welcome to attend the next 3 days, because we have 4 terminals there available, and that's from anyone who wants to access Guam law and federal law, any law that we have as part of our database.
Okay, thank you. And I just wanted to make that
Thank
statement
you.
because
Yes.
sometimes they ask me, and I basically tell them, go to the Law Library, you do
yes,
have access.
We're there, and we're open 10 to 6.
Okay.
I'm sorry, 8 to 6.
Thank you.
6.
Thank you.
I just have a general question on, right now, I guess the compiler, the office of the compiler is under the judicial branch?
That's right.
Yeah, and with your explanation here about, basically a lot of the work that you do is bring into finality what has been enacted, what was started here, signed into law by the governor and all that. And it seems a lot of that interaction is between the compiler and the legislature. And I'm just wondering, maybe just enlighten me, why wouldn't it make more sense to have the compiler under the legislative branch?
Oh, see, this is, you know what, and really, I've done my research. When the legislature was first created, and the compiler's office was actually not the compiler's office, it was Attorney Bond, for anyone that remembers. And it was part of the Law Revision Commission in the Guam legislature. And it had been that way for years until, I'm not quite sure, the year when it went to the AG's office. Mr. Troutman was with the Attorney General's office. So it went from the legislature to the executive branch in terms of compiling the Guam law. That was before your time too? Do you recall?
I don't know. I know exactly what you're saying, but why, I don't know.
I'm not sure either. To let you know, it was originally with the legislature, because if you look at any of the old redbacks, they were there, or the greenbacks, not even by the red, they were with Mr. Troutman. With the old green books with Attorney Bond, they were with the Law Revision Commission here in the legislature. I'm not sure.
And since you've researched it, then what's your recommendation?
Personally, I would leave that to the lawmakers. I would leave that to the lawmakers.
No,
I'm happy to execute my statutory mandate, but I've seen it in different forms throughout the years when I met with the Office of Law Revision Counsel, and that's the U.S. Code Publishers.
Yeah.
They're part of the House of Representatives.
Yeah, I guess, I've always subscribed to the notion of if it ain't broke, don't fix it. And if the fact that we're over on the other side of the street and that alone, does not cause any kind of inefficiency, I guess, in the work that you're trying to accomplish, then maybe we should leave it alone. But if things can be made a bit more efficient by maybe putting it back under the legislature, then that's probably something that should be considered.
All I'll say is the compiler of laws is an unclassified position. And in the big picture, as an unclassified position, you serve at the pleasure of the appointing authority.
Okay.
So it would depend on who the appointing authority is and whether I would have a job in 2 years.
Thank you. And thank you for your presentation. I think it's been very helpful. If nothing else, I've always I've heard about the compiler's office, but wasn't quite sure how to use them. There have been times when I would introduce, or as we're working on a bill, I'm not quite sure under what section to put it, so I put it under the all others category and leave it to the lawyers to figure out.
I have met with members of your staff,
Okay.
really productive conversations about where to put things. And like I said, I welcome anyone to call, because it's easier, as you mentioned, at the front end to find out, how to number it, where to put it, what makes sense, or what even would be any use for the senator's office. We'd be happy to help out.
Thank you. And I have to say that I think your presentation, I think is, certainly shows that you've got a good grasp of the material, and I'm sure your staff also provides good support.
It's a team effort.
Thank you.
Thank you very much. Thank you.
Just to expand, of course, on the discussion earlier about where maybe the compiler of law should be under. There's some discussion, in terms of probably setting up a legal division, within the legislature, to have a team of, legal attorneys maybe to, consider the drafting of legislation, making sure, of course, that they're in the right sections, and more importantly, to make sure then that we'll be able to communicate with the compiler of law. So just know that there, are some discussions on that, subject area. So
I think my goal, along with the goal of the senators, as long as the laws are easier to find, better written, and available to the public, that's the goal. And I'd be happy to work with whatever the end product is.
okay. Are there any questions from the clerk's office? Okay. Well, just to reiterate, of course, what the senators have said, we do appreciate you taking the time to do this. It was long overdue. We've gotten several concerns earlier about the updating of the laws, and we just want to make sure, because it's crucial to what we do, and that we understand, of course, how now we just seeing how you've able to set up that source section. Explains it all to us. So, and we appreciate your assistance at any time that any one of the senatorial offices should call. We want you to know we do appreciate that. So,
Thank you.
if there are no questions, I want to thank you. I can't even see the clock to determine what time it is, but this informational, session is adjourned. And thank you so much for
Thank you,
your
Mrs. Speaker.
presence.
Thank you, sir. Thank you, Mr. Chair.